Bongbong Marcos, absuelto na sa 203 billion estate tax. Tax expert na mismo ang naglinis ng pangalan ni Bongbong Marcos. Laking sampal nga ito kay Rowena Guanzon, Eli Buendia, Isko Moreno at iba pang kampon ni Leni Robredo. Laking sampal nga ito sa mga kakamping na pinagpipilitan nito na dapat bayaran ni Bongbong Marcos ang 203 billion estate tax. Dahil sa isang magandang balita ang lumabas mula sa The Manila Times, tax experts at legal experts na mismo ang nagsabi o nilinis na ang pangalan ni Bongbong Marcos dahil nga ayon sa kanila, kumbinsido ang mga eksperto sa buwis at legal na hindi maaaring sisihin si Bongbong Marcos sa kabiguan ng kanyang pamilya na bayaran ang mga pananagutan sa buwis sa ari-arian nito. Narito ang full report mula sa The Manila Times. Tax and legal experts are convinced that presidential candidate Ferdinand Bongbong Marcos Jr. cannot be faulted for his family's failure to settle its estate tax liabilities. In a phone interview with the Manila Times over the weekend, former Senate President Ponce Enrile said cases involving the Marcoses' tax debt are still pending in the Supreme Court and the Court of Appeals. Enrile taught taxation in college and was finance minister during the term of President Ferdinand Marcos. He earned his Master's of Law degrees at the Harvard School of Law with specialist training the international tax law. Enrile said the cases have to be settled first before the Bureau of Internal Revenue can demand that Marcos Jr. and former First Lady Imelda Marcos, the administrators of the family estate, settle the tax debt. The Department of Finance has reportedly been pressing the BIR to collect the unpaid taxes from the heirs of the late president, which have reportedly ballooned to around 203 billion from 23 billion. Last December, the BIR sent a letter to the Marcos heirs demanding that they pay the tax dues. But Enrile said the job of an estate administrator is to gather the assets, gather the liabilities, and then establish the plan of partition. Sell the assets to pay liabilities. If the administrators are not able to sell the assets to liquidate the liabilities, and if they indicate this in their tax returns, no violation exists, Enrile said. Marcos Jr. needs to go gather all the assets and all the liabilities and then liquidate it. Then after paying the liabilities, after paying all the taxes, they will submit to the court. Partition of estate. He has to file an estate return, he said. A process that takes time because some of the assets are considered to be ill-gotten wealth. Despite the Supreme Court ruling of June 5, 1997 on the Marcoses' estate tax liability, there are still pending criminal and civil cases against the family and its cronies before the High Tribunal and the Sandigang Bayan. Former Internal Revenue Deputy Commissioner Edwin Abela told the Times the estate and the executor and administrator of an estate have separate and distinct personalities. That is why the estate has a separate team. Abela, a tax law professor and a bar reviewer, said it means that the government of the BIR in particular just need to go after the estate itself. Abela said President Rodrigo Duterte cannot reverse the decision nor preempt and make the decision himself. The tax code is clear on this. The Marcoses have been subjected to harassment since they left office. In fact, their properties have been subjected to auction and have been sequestered, he said. Abela said the government can only get a fraction of the state to be taxed and cannot be more than the whole property, which is considered unconscionable. Several jurists who talked to the Times on condition of anonymity said that the tax claim could be covered by prescription. One jurist faulted the government for going after the Marcos estate. He said the government cannot execute claim because the properties to be covered have yet to be determined due to the pending cases before the High Court and the Sandigang Bayan. Another source said that under Section 203 and 222 of the National Internal Revenue Code, the government must execute a tax claim within 5 years in good faith and 10 years if there is fraud committed. Likewise, an internal revenue tax, which has been assessed within the prescribed period, may be collected by distraint or levy or by a proceeding in court within 5 years following the assessment of tax, the Times source said. It cited the Supreme Court case of Lara Diluanco versus Commissioner of Internal Revenue on the reckoning period for the collection of taxes. In case self-assessed taxes like income tax, the date of the actual filing of the return is considered as the date when the tax is said to have been assessed. For collection by judicial action, the action is deemed instituted upon filing of the corresponding complaint in the court of competent jurisdiction. In case of summary remedies, the period is reckoned from the service of the distraint and levy on the persons or entity authorized to receive the same, the source said. Senator Aquilino Coco Pimentel III was the BIR investigated for failing to collect the tax due on Marcos estate. In filing Senate Resolution 998 on March 28, Pimentel raised the need to identify the BIR officials, past and present, responsible for the non-collection of the estate tax since 1997. He said the BIR has the power to assess and collect national internal revenue, taxes, fees, charges, and to enforce the necessary forfeitures, penalties, and fines. He said that on June 5, 1997, the Supreme Court affirmed in toto the Court of Appeals decision that the deficiency income tax assessments on the Marcos estate were final and unappealable. The case has long become final and executory, and thus by the legal principle of res judicata can no longer be questioned and hence should be fully implemented and executed, Pimentel said.